Smith.
My Lord. My Lords, before I come to my final observations, the 2 points arising from discussions over lunch that I would briefly make, if I may. And the first is over this business of our correspondence with the Secretary of State. My Lord, we don't think there's a great deal from us, possibly one email asking for our supplemental skeleton and us giving it, but we will give what we can. But it leads me to this observation, just to remind the Court that, of course, it is no part of our case that the Secretary of State should be here. Our case is we should be compensated by them, and then they can have the difficult and expensive discussion around whether it's the MIB or the Secretary of State between them elsewhere. And there is this point around effectiveness and access to justice. This is a PI case, and as such, there is access to justice for people like my client who are indigent litigants. We benefit from quoques. A Frankovich damages case has no quoques. It's not a PI case. It is a considerable risk. One must try to get ATE insurance. That is something of a feat these days, not least before disclosure, showing whatever the internal workings of the Secretary of State might have been. And not least, because they wouldn't get out of this entirely, the dealings between the MIB and the Secretary of State, because these cases are unique cases where the relevant legislation, so to speak, involves also the agreement between the Secretary of State and the MIB. So it's a difficult and risky business, and it's very different to a directly effective PI claim, such as this.
Is this claim against MIB, does that count as a PI case?
Yes.
How does that work?
Well, because it is, because that's what they're there to cover.
Because you're directly going for your compensation.
Yes.
For the injury.
Yes.
Okay. Right. I'll take your word for it.
And so, my lords, the other point is...
My lord's question just sparked a further question in my mind, to which no doubt there's a very straightforward answer. But in the Frankovich claim, would the measure of damages be exactly the same, or is there some kind of element of loss of a chance or anything like that?
That's a very good question, my lord, to which I don't want to give a definitive answer off the cuff. But in principle...
in principle, you'd expect it to be the same.
The chance would be a fine thing because you've got judgment against Mr. Shuker, so there's not much risk in terms of that sense. You go straight to the assessment of damages.
I mean, the principles of equivalence and effectiveness suggest that that ought to be the case.
To be the same.
Yeah.
Okay, thank you.
With the slight caveat that there might be something I haven't thought of. And anyway,
well, there doesn't seem to be anything in the fourth defendant's defence about it.
No. And but also, it's one of the things about Frankovich damages claims, there weren't many that fought to the end. So it's not a vastly well-established jurisdiction as far as the assessment of damages at any rate is concerned. But there it is. My answer is, in principle, I would say yes.
Thank you. And you'll contribute your modest addition to the bundle of correspondence.
For what it's worth.
Would my lord like the pleadings as well? Would that be helpful to have the contribution notices and defence?
Yes, I think so, please, yes. Perhaps if it could all just be in a little clip, that'd be very, very handy, yes.
Now, my second point was that I'm reminded that yesterday my Lord Justice Stuart-Smith asked my learned friend, Mr. Delamere, what the position in Lewis and Tyndale would have been if there had been insurance in place. And my learned friend's answer was it would have been different. My answer, if your lordship is interested, but my answer to the question is the outcome would have been exactly the same. The insurance company would have refused to pay out because the vehicle was not covered for accidents on private land. RTA liability didn't cover private land. So Mr. Lewis would have failed in a claim against the insurer we would have had the equivalent of the O'Farrell J judgment in this case, because he would have been unable to use horizontal direct effect against it, private party versus private party. Then Mr. Lewis would have turned to the MIB, as he did, and we would have had the same arguments, quite possibly word for word, between Mr. Mercer QC and myself, and exactly the same result, because as I submitted yesterday, nothing in the argumentation and in the way that the question was framed by the Court of Appeal, as we saw, is to do with there being no insurance. So the failure to provide for compulsory insurance cover on private land would have been found to have been a breach by the state for which the MIB was liable. Just the same way, whether the insurance was in existence or voided or otherwise not paid. So, my lords, those were my 2 lunch points. That brings me briefly to my 5 minutes on the judgment below.
Thank you.
The judgment below is in Authorities Bundle 6A at page 80. And we see what the position was at the outset below, seems a long time ago, at page 93. 93, paragraphs 43 and 44. And we see that this hearing happened after the hearing before Mrs. Justice O'Farrell. The MIB didn't contend in the 3rd line that the decision of O'Farrell was wrong. And in the last few lines, a claim against the guarantee bodies, a claim of last resort, could not succeed if there was an insurer which was liable. So the broad position, as it should be under the directive, was in issue. Should have been an insurer, couldn't succeed if there was an insurer which was liable, but there was not. And it is therefore now necessary to consider the claim against the MIB made in circumstances where the claim for compensation against the insurer has been struck out. And as is so often the case, a lot of the things that are discussed in the judgment have become considerably clearer in this court. It's to some extent evidence, but it's perhaps useful to point out that things were, every point, including the points not under appeal, was taken below. And so the lengthy discussions of the Travaux and the case law and the concept of uninsured in Mr. Justice Freedman's judgment, which he usually uses in the way that my learned friend Mr. Delamere uses the phrase wholly uninsured, all of those discussions, as well as the longer wording in Article 3, are perhaps lengthier and more complex than in my respectful submission they need to be, but that may be in deference to the very extensive and skillful submissions made by my learned friend Miss Kinsler below, or the inadequacies of my response, and to cap it all, the whole thing was done online, my lords. But I submit that the whole thing is summed up in what I say is the ratio of this judgment, and that's really all I want to look at, because I say it is the decision in a nutshell, and that is at page 120 of this document. After all that's gone before in the previous 124 paragraphs, in short, just by the first hole punch, in short, the words in Article 10.1 of a vehicle for which the insurance obligation provided for in Article 3 has not been satisfied are broad enough to include any breakdown in the system, whether due to the vehicle being uninsured because of the driver or its owner, or the vagaries of the national legislation. In this case, one that created the declaration in section 1522 of the RTA 1988, as Flo LJ found in Lewis. So, my lords, pausing there, we have here in a nutshell all of those issues around what's the nature of the obligation, the obligation of the driver, the obligation of the state. It is all of those, Lord Justice Warby's points, and we have the vagaries of the national legislation, the words of Mr. Justice J and Flo, Lord Justice Flo in Lewis. The words in Lewis, I carry on, the words in Lewis applying the directive are broad enough to include a case of the insurance obligation not being satisfied because the insurance does not cover use of the vehicle on private land, a fact in Lewis, or because it is and has been subject to avoidance under section 1522 as it then was. And this is, of course, accepting my submission to that effect, which was the same below as it was today here. This provision is incompatible with the directive and has been acknowledged as such by the Secretary of State. The effect of the existence of section 1522 and the declaration in this case is that it was a vehicle for which the insurance obligation provided for in Article 3 has not been satisfied, and or the vehicle, for some reason the underlying lining stops, was equivalent to or treated as an uninsured vehicle. See the opinion of Mr. Mingozzi in Chonka and Richards LJ in Delaney, referred to above. So it's either or both. Reference is again made to other parts of this judgment which discuss Lewis. And then 127 is the second paragraph in which I say that the ratio is to be found. The submissions of the MIB to contrary effect run contrary to the reasoning of JJ in Delaney and of Richards LJ and of Flo LJ in Lewis. These submissions are not only inconsistent with the cases of this jurisdiction, but also with the European cases cited above. They would treat as a lacuna a case where a victim had no remedy against an insurer, where the vagaries of the national legislation exempted the insurer from liability. This does not meet a purposive understanding or the plain text of the words in Article 10.1, a vehicle for which the insurance obligation provided for in Article 3 has not been satisfied. So there again we have the principal method of interpretation of a directive, which is purposive understanding, i.e. Applying the objective of the directive, as well as the plain text. The words themselves of the directive are wide enough. And the last sentence over the page at 121, those words refer both to the case of the uninsured vehicle and to its equivalent where the vehicle is insured, but a vagary of the national legislation of the member state gives rise to the insurance obligation. Not.
So that would apply to an exclusion clause as much as to an avoidance.
My lord, yes. Yep. But it certainly applies to avoidance. So, my lords, that is actually all I wanted to point out in Mr. Justice Freedman's judgment, because I found it a helpful summary to get around perhaps some of the more extensive discussions in the earlier parts of the judgment. I'll just see if there's anything else. Well, my lords, those are my 10 minutes, unless I can help your lordships further.
No, thank you very much indeed, Mr. Mason. Yes, Mr. Miller.
Lord, I'm conscious I've probably somewhere near exhausted your patience already, but I have a few points to make. Let's start with where my learned friend left, because the effect of his submission, and it's obviously the ratio of the judgment and the effect of his submission which it accepts, is that the MIB has to underwrite the satisfactory delivery of the UK's obligations in all respects under the directive in relation to Article 3 and 13 and all of the provisions of the MID that feed into it. Any breakdown in that system is impermissible under the analysis of no lacunas, total effectiveness, etc., such that if for any reason a party receives less than the full compensation demanded by the directive, it's my client that ultimately has to pay. And as was clear from the answer given to the question just now to my Lord Justice Stuart-Smith, that is even the situation where the policy of insurance subsists, hasn't been avoided, but a head of liability has been excluded or capped or limited in some way that is inconsistent with the requirements of the directive or of community law, such as the principles of non-discrimination which it brings with it. In any and each of those circumstances, My learned friend's case is, well, if I don't recover that money from the insurer whose policy may still subsist, I'm entitled to come to you, the MIB, and ask for you to pay the difference. That's where his argument necessarily has to go, because of the width of the long term and the meaning he attributes to it in Article 10. And it means whenever the recitals refer to, and you've seen how repeatedly they do, to an uninsured vehicle, what that means is a vehicle for which the insurance either is avoided or doesn't deliver the totality of what is required under the directive. Now that is, in my submission, a very different argument to the one that was canvassed in Lewis and Tyndale, and I'll come back to deal with that in terms. But the first point to make, and I go back to the first point.
But your starting point is acceptance that
Absolutely.
the insurance obligation with which the UK is meant to comply should deliver in all those circumstances.
Yes, I'm going to explain how we analyse it, my lord, but the starting point is we accept that if, and this is the if that is the heart of this case, if there is the obligation my learned friend describes inherent in Article 10, then we accept that Article 10 is directly effective, and we accept that the MIB is the body, it is the emanation of the state that is responsible for meeting that obligation. Those 2 points, direct effect and the MIB being the responsible body, were the 2 issues that were live in Lewis and Tyndale. We don't take issue with either of those 2 issues. Our point is a quite different one, which is about the content of Article 10. And as you'll remember from the paragraphs in Lewis and Tyndale, there was no debate about the scope of the duty under Article 3 and Article 10 in Lewis and Tyndale. Why is that? For the very simple reason that 2 years earlier, Mr. Justice Ouseley had already found the RTA to be in fundamental contravention of the requirements of EU law and the Van Up case in particular. Lewis and Tyndale wasn't an argument like this case about whether or not something was subsumed within the duty of Article 10. It was a case about who pays if it is within Article 10. So the reason I was going to come back to the who pays point, it's a simple one, but it's worth making. If the MIB is required effectively to underwrite the totality of the UK's implementation of this directive, that will have a direct bearing on the premium that every single motorist pays. Because effectively what it says is that if there is any shortcoming in the scheme, it's one that has to be borne by the motorists through their insurers as authorised insurers, because the way the MIB is funded is by levies on the insurers, and those levies are necessarily passed on in whole or in part to those that they gather insurance monies from. So that's what this case goes to, and that's why the who pays point is important. Can I then just deal with a point of detail, because there was discussion about the Article 75 scheme. The answer to the question posed by my Lord Justice Stuart-Smith, why is this case outside Article 75, is contained in paragraph 17 of our skeleton argument. Yep. It's the point that does turn on the agreed fact, number 6, because under the operation of the 1999 agreement, the fact that the claimant was getting into a car for which he knew the driver was not an insured driver was a proper basis for the avoidance of any liability by the insurer under the scheme. And that entailed the application of the case law, White and White, which my Lord may well be familiar with. It's cited in Delaney in the judgment of Mr. Justice J at paragraph 25, page 1015 of the bundle, if that's helpful. That's why this case is outside the 1999 agreement, and that's why the argument in this case is exclusively on the plane of European law. Now, I was struck, a terrible sycophant that I am, by something Lord Justice Warby said in the course of argument about the 2 strands of analysis that one can see in Article 3. And that is, with respect, a very good way of putting it. Because one strand of the case law is about the scope of the duty to insure. In what circumstances must you insure your car? And that's what Lewis is about. Must you insure your car for its use on private land? That's what Juliana and Ostrowski are about. Must you insure your car when it's in the garage? Is this a car that requires a contract insurance to be in place? That's what all the vehicles cases like Lewington, etc. are also ultimately all about. Is it a vehicle that requires to be insured? If it does require to be insured, and it's not insured, then obviously the case responds against the MIB. Because if it's a car that requires to be insured, it's in your garage but you haven't got your statutory off-road notice, and someone takes it out and uses it, then you're in an Article 10 situation. But the second strand of the case law is about the quality and content of the policy of insurance that has been taken out. And that's why, with respect, the question my Lord Justice Stuart-Smith posed about exclusions is so very on point. Because the logic of my learned friend's case is that Article 10 operates even where there is a policy of insurance in place, even when it hasn't been avoided. Let me give you a very simple example. You heard about the twocking scenario that's coming down the pipeline. If my Lord turns up Authorities Bundle 1, tab 3, and looks at section 151 of the Road Traffic Act, page 21 of the bundle, and you look at the language of section 151.4, page 21.
Thank you.
This is the implementation of what I called the Joyrider Exception in Article 13, paragraph 1, subparagraph 3, or whatever it is. And here you have the language. Was the person allowing himself to be carried in or upon the vehicle, did they know or have reason to believe that the vehicle had been stolen, and then these words also appear, or unlawfully taken. Now,
I'm very sorry, you're on page 21?
Page 21.
I think it's 11, is it?
Maybe I'm looking.
I'm looking at section 151.
There's any number of versions of section 51 in the bundle. I'm looking at the one that's in force at present. It's in identical form to the other one. There's one version at page 6 as well, which is the version that was in force from June 7 to 29th of June 2015. It hasn't changed materially at any stage.
Okay, which subsection are you looking at?
Subsection 4.
Thank you.
This is the subsection in consistent terms that implements the Joyrider Exception. Stolen or unlawfully taken. Now I apprehend, I know literally nothing about the case, but I apprehend the argument is going to be about whether or not the words or unlawfully taken are consistent with the requirements of the directive. And you can immediately see that that argument is going to produce exactly the same type of Smith and Mead scenario, because the question will be whether or not they can be mal leasing interpreted or contra legem interpreted, and you can see immediately there's a risk, we don't need to speculate on where it pans out, that the court will conclude that the plain language of the term is, irrespective of what community law requires, that the insurer is entitled to exclude against somebody who's twocking a car. Now, in that circumstance, and no doubt the reason I've been instructed, because the MIB is sitting in the background, the argument is going to be that notwithstanding the fact that there is a policy of insurance in place, hasn't been avoided, it's just that a head of liability has been excluded. Notwithstanding that, the car is to be treated as an uninsured vehicle because it doesn't provide the full and comprehensive package of insurance that the directive requires. I could give you any number of examples of provisions in the MID that could produce exactly the same effect. Indeed, I gave some examples in opening, and I noticed my learned friends didn't engage with them. The obvious one is the caps that are permissible, and whether or not they've been uprated or not, or whether or not they operate in a discriminatory fashion. Another example is the operation of the provisions under Article 5 and whether or not they're operated, the special plates and all that, in a fashion that's consistent with the directive. Each and every one of those circumstances, the problem may not lie in the vehicle being uninsured, but rather in the quality of the insurance or the limitations inherent in it. And the simple point we make is that it is plain, on the basis of the sources I identified in opening, that that latter category of case does not trigger liability for the guarantee fund. That's evident from the language of the provisions, it's evident from the travaux. The travaux are directed explicitly at excluding that category of case, and it's evident in particular from the Mendozzi reasoning that goes into Sonka and then Fidelidade. That's the terrain for dispute, and really the question before the court, therefore, is whether or not there are those two strands, those two dimensions. The Lewison Juliana, when must you insure line of cases, and the Delaney line of cases, this line of cases is how must you insure, what must the policy do, when must it survive, etc. And that is, of course, the answer to all of the case law that talks about coextensivity, because the coextensivity language is all in the cases that fall in the first bracket. It's directed at the point that if there is a duty to insure, as there was in Juliana, then it must be the case that there's a duty to compensate if someone has driven a car which there was a duty to insure and has not insured. That's dealing with, in respect, quite a different problem from the problem of avoidance of policies or exclusions of liabilities in policies. And you've seen from the travaux préparatoire that what has become Article 13 was the legislative response to the problem of both avoidance and exclusion. Now, there was a point when my learned friend was going through the travaux préparatoire this morning when he suggested...
It's a legislative response to what?
To the potential problems posed by avoidance or exclusion. There was a point when he was going through the travaux this morning where he said the Commission couldn't have had in mind a problem like Section 152 or avoidance of policies or matters being treated as void ab initio. That wasn't what was in mind, it was the problems of exclusion. That's the language that was employed in what was, first of all, Article 2. That is, with respect, utterly impossible to reconcile with the contemporaneous materials. And if I could ask you just to take up page 422 of the first authority bundle, you will see that it was the problem of avoidance that the Commission had squarely in mind. Avoidance in factual circumstances identical to this case. And I made that point yesterday.
Which paragraph? You in 3?
It's 422 at the foot of 3. I said that yesterday that the language about the insurer can avoid payment of any compensation to the victim, claims invalidated by false declarations of risk, damage caused by intentionality in France, etc. This hypothesis relates to Article 1.3. Was about avoidance. It's about the facts of very like this case. So the idea that there's some nice distinction to be drawn between exclusions and avoidance as a problem is unreal. The evil that the Commission was seeking to address were provisions in a policy or in the rights surrounding a policy that enabled an insurer to evade the obligation to pay to the victim the totality of the sum due, subject to any limits. And with respect, once that point fell away, my learned friend had literally no answer to the argument that here was a legislative proposal from the Commission to do the very thing that he says Article 10, as it now is, should do, in explicit terms, And that proposal was explicitly rejected by the council. There was literally no answer to that. And you've seen how in cases like Ruiz Benaldez, the Commission attempted to revive that argument and how that was rebuffed by the court. That is, in my submission, a critical starting point for the analysis of the content of Article 10. And it's the first plank in the argument that you must draw a careful line between the two strands of case law. What then about the uncertainty of remedy, which was another theme of my learned friend's argument? He said that the vice here is the uncertainty of the Frankovich remedy. And he developed that point further this morning by reference to domestic, just now by reference to domestic funding considerations. The answer to that concern about the uncertainty of remedy is that this is the remedy that has been expressly identified by both the Advocate General and the European Court of Justice. And that takes you straight into the Smith and Mead analysis. If it's good enough for the CJEU, and they see it is the ultimate means by which the demands of the system are to be given effect, then with respect, it should be good enough for this court. So what we come down to, in terms of the answer to Smith and Mead, is the ingenious argument that because the MIBI was not a party to the litigation at the time that the reference was made, it must be taken that the court wasn't having any concern or consideration of the potential for the answer, the problem of the potential lacuna lying with the MIBI. Now, there was more than a whiff of the unreal in my learned friend's submissions about how exactingly concerned the CJEU is with procedural niceties, given how often they fundamentally recast questions or move the direction of analysis and argument. But it was, I would suggest, particularly unreal to make that submission in circumstances where, first of all, the judgment in Farrell and Whitty, which you have, number 2, which you have at tab 31, was handed down by the Advocate General on the 22nd of June 2017.
Just take it a little bit slow if you want us to remember this.
Yes, it's
So,
page
authorities
761.
31.
Page 763, if you look in the little box in the top left-hand corner, you'll see 5th of July, that's the argument date. 22nd of June 2017, that's the date of the Advocate General's opinion. 10th of October, that's the date of the court's judgment. So the court's judgment was on the 10th of October 2017. You can see that Farrell and Whitty was a grand chamber case. That means it's making big ripples in Luxembourg. Only a small percentage of cases go before the grand chamber. Then look at Smith and Mead, and you will see that the hearing in Smith and Mead occurred 8 months later, on the 5th of February 2018. The Advocate General's opinion was on the 10th of April 2018, and the court's ruling was on the 7th of August 2018. And if you count up the judges in this second Grand Chamber case, who were also judges in the first Grand Chamber case, you get to a sum total of 9 of the judges, having just recently decided Farrell and Whitty number 2. So the first point is, obviously, they'd have had their ruling of Farrell in mind, and we know that that is the case because Farrell is expressly, number 2 is expressly name-checked, first of all by the Advocate General, at paragraph 57, page 860, and again at paragraph 60. But the second reason why this "they're not a party" submission is unreal is because of the simple contents of paragraph 62. Look at what the Advocate General goes on to say. He says, if, in the Irish system, the payment of subsidiary compensation, by which I take it to mean something akin to payment under the uninsured drivers agreement that goes above and beyond the statutory arrangements of visible in the RTA. If the payment of subsidiary compensation by the guarantee body is not provided for where the owner of the vehicle has an insurance policy and that policy does not cover a particular risk. In other words, if he's saying the MIBI agreements don't respond, which it ought nevertheless to cover if the state had correctly transposed Article 1, it falls to the state to bear the financial consequences. So the Advocate General is already considering, quite explicitly, the implications of this analysis for the MIBI. It's bizarre if the true answer is, according to my learned friend, that it's actually that guarantee body that is itself obliged to provide compensation under Article 10.1, that's not mentioned in that circumstance. Nothing held the Advocate General back from speculating about how justice can be done in the circumstances of this case. He's identified something completely different. And in my submission, when you look at the court's exercise at paragraph 56 that I showed you, it's exactly the same problem being addressed. What happens next? And again, the solution is a Frankovich claim. You can't escape the logical consequence of this analysis by simply saying that the MIBI was not a party. That is, in my submission, an unreal answer. And with it, of course, falls away all of my learned friend's arguments about effectiveness and lacunae, etc., because the CJEU has expressly identified the lacuna that arises when a state breaches Articles 3 and 13, so that's the factual scenario of Smith and Reed, and it has said, in terms, that the remedy is a Frankovich claim. Now, then turning to the Frankovich issues, let me just very briefly elaborate the point I made somewhat rudely when I jumped up this morning. It is no answer to the Frankovich analysis to then pray and aid the special circumstances of the United Kingdom after Brexit. This case is to be answered by reference to the law as it stood at the time of the accident. That's section 16 of the Interpretation Act and everything that flows from it. As it happens, my learned friend's cause of action in Frankovich has survived, and that's all that's material for present purposes. It's been preserved by the provisions he correctly showed to you in Schedule 8 of EUA 2018. It is nothing to the piece of the EU analysis that there may be difficulties in the UK in the future in giving effect to the remedy that the EU has identified. That's back to front reasoning. That's to pray in aid, I'm afraid, the merits and the hardship story to recast the law. And I invite you to resist that. What is an acceptable focus, I would suggest, is Lord Clyde's test. I do have to accept, and I did very clearly, right from the get-go, that the distinguishing element of the claim under Frankovich is the need to satisfy the sufficiently serious breach test. I stand by everything I said in opening. There are, even before you get to Candolin and the clarity of the law from 2005 onwards, which in itself would be fatal to any argument to be made by the Secretary of State, there are two things about this case that drive you to the conclusion you're in the terrain of a sufficiently serious breach. The first is the nature of the obligation that has been breached. It is a guarantee obligation. It's an obligation to pay money.
I'm not sure I understand that.
Well, many obligations are, under EU law are obligations to do certain things, to provide cross-border services or to not impose impediments, etc. Take Factortame, for example. The obligation there was to accord free movement. It doesn't immediately crystallise arise in some form of financial gain. It takes you into the realms of economic loss and analysis of economic loss. Whereas here, the nature of the obligation is effectively to guarantee the payment of a particular sum of money. It's a bit like, there are other instances of such guarantee obligations in EU law. I recently, in this court, did a case about the guarantee obligations that exist for pension funds and the state's obligation to secure that you get paid at least 50% of your pension in the circumstances of your employer becoming insolvent. There are similar guarantee schemes, like the one in Frankovich itself, to guarantee the payment of unpaid wages if your employer goes to insolvency. Where the nature of the obligation is to ensure that a particular sum of money is paid, inherently, the breach of that obligation is far more likely to be a serious one. That's the first point. That's why Lord Clyde identifies the nature of the obligation as being important. And then secondly, you have the nature of the breach. How far is the right that is to be protected intruded upon? And here the breach is total, because the effect of section 152 is to enable the party that should pay to avoid the totality of its obligation. When you layer on top of that, how long has the law been clear? And it's been clear since 2005. We say the case is unanswerable. And it may be, it's speculation on my part, I can't deny it. It may be, but it's that reason that the law has been so clear for so very long in relation to the impermissibility of exclusions, that is why the CJEU said what it did about the Frankovich remedy in Smith and Mead.
Is that a submission about the merits?
No, it's more a submission that it seemed it would be obvious to the European Court of Justice.
No,
that's a real remedy. Exactly. I see my point.
In this case.
Yes, it is. It's a submission of the CJEU's perception of the likely merits of such a claim.
But it's saying, please, Court of Appeal, don't be affected by the suggestion that he may not have a remedy.
Well, it's in part of that, of course.
Well, I'm only asking because you just criticised Mr. Moser for straying into the area of merits.
But straying
into the area of merits.
No, I think my point is a different one with respect. What I'm saying is that the CJEU see it so obvious that you're going to get a Frankovich remedy in the circumstances where it's been banging the same drum since 1999.
But isn't a simpler way of looking at it just to say, if you're advising a claimant with a multi-million pound claim to choose between an action against the MIB in which this line of defence was not available,
of course,
and an action, a Frankovich action in which it was, you'd obviously advise the former. And if you were stuck with the latter and you were being offered something less than full compensation because of litigation risk, you'd have to advise accordingly.
Of course, my lord.
Right.
That's why I've accepted from the get-go it's an additional hurdle.
Yeah.
Absolutely. There is a difference between the direct effect claim and the Frankovich claim, and the essence is in the latter.
Absolutely. But we should ignore that. We should simply look at the quality of your submission on the interpretation of the article.
A, that, and B, you should look at what the CJEU say is the remedy for any breach of the kind we're faced with, which they say is a Frankovich. Now, I do also point out that the minute you expand Article 10.1 and the long-term in it to embrace vehicles that are still insured, but imperfectly insured, into the meaning of uninsured vehicles for the directive, which is the term used in the rest of the recitals, the rest of the operation of the directive becomes a bit of a nonsense, because it depends for which purpose you're looking at the vehicle as to whether or not it's an insured or uninsured vehicle. How are all the regimes for cross-border claims, etc., to work if the answer as to whether or not a vehicle is a vehicle that's insured or uninsured depends upon the nature of the claim and whether the risk in relation to it has been excluded or not? They just don't work. And that's the logical position the learned friend is driven to. Anything that provides less than the full protection that the directive requires means that the vehicle is to be treated as an uninsured vehicle. That just can't be right. And that's why you shouldn't be drawn into effectively treating Article 10 as a guarantee that ensures that every aspect of the dimensions of the quality of the insurance policy that is required is somehow underwritten by the MIB. What then of the Lens Backstop? A very snappy term, trademark P. Moser QC, and sure to feature in the judgment. The problem with the Lens Backstop is it's never been adopted by the CJEU. Advocate General Lens is not the CJEU. It wasn't adopted in Ruiz Benaldez itself. It wasn't adopted by Advocate General Mengozzi in Shuker. He went through the same travaux préparatoire and came to a different conclusion. What you don't get is the same kind of only if reasoning that my learned friend latches onto. And it's equally not evident in the analysis of the court in Shuker, in Fidelidad, in Smith and Mead, which is where you would expect it to have surfaced with Moby Dick-like abandon if it was featuring in the court's analysis. It's nowhere to be seen there. And you don't see it in Liberty Seguros. So what you're left with is that this was the view of one Advocate General in 1999, or whenever it was back in the 90s, that hasn't featured and indeed is inconsistent with the reasoning of the court since. And I would suggest that if you read Fidelidade, which is, I think we're all agreed, the key case, if you read Fidelidade, you will see that it is entirely inconsistent with the Lens Backstop analysis. Now, what my learned friend sought to persuade you, to try to get you out of the inconvenient effects of Fidelidade, was that, first of all, what was before the court was necessarily some kind of mar-leasing dispute. We simply don't know. We simply don't know. It seems highly plausible that there was a question of Portuguese case law that was capable of being dealt with by mar-leasing interpretation, but we certainly don't know that as a certainty. But what you do know from paragraph 18 was that the potential voidness of the policy was a real risk or consequence of at least one of the strands of analysis, and that strand of analysis, if it were adopted, would, on that analysis, have led to an incompatibility with Article 3. It cannot be the case, as my learned friends suggest, that the Portuguese court was simply inviting the CJEU to decide between different strands of case law, both of which were consistent with the demands of Articles 3 and 13, because if that had been the case, the question would have been academic, and it would have never been raised and referred to the CJEU. It's like rule 1 of framing a reference. You don't ask questions out of curiosity. They have to have a material bearing on the outcome of the case. And it's quite plain from 18. But what is being said is that if the nullity solution is invoked against the victim, that solution may give rise to a breach of Articles 3 and 13. And the reason it's said that you can go for that nullity solution and allow that to be invoked against the victim by the insurer is that you needn't worry because the victim is always going to be protected by the FGA.
Where does it say in paragraph 18 that the nullity being considered there would be in breach or would constitute a breach of Article 13?
Well, that's obviously the predicate of the question, because why else would the question of whether or not there's protection under the FGA arise?
Well, my lords, I hesitate to rise, just for the sake of completeness. I never said that both options in Fidelidade were in accordance with Articles 3 and 13. I said that there was one option that wasn't in accordance with Article 3, where it fell back on the body in Article 10, And there was one option that
Well, the
was.
question didn't arise because it was the second strand.
Yes, that's right.
That's what I thought.
Well, I'm guilty of not listening sufficiently carefully to my learned friend in that case. In my submission, it's pretty plain what's going on, is that there's one strand of argument that is potentially consistent with the demands of Article 13, and one which isn't.
Yeah, but Mr. Moses' point is quite simple, as I understood it. That what is being said in paragraph 18 is if you have avoidance as a result of
Yes.
nullity, that approach takes account of the fact that the victim will always be protected by the fund. That's the point, as I understood it, that was being made. And so it's being taken as accepted and almost not worthy of comment that a case such as is outlined in paragraph 18, which is analogous to our case, leads to a claim upon the fund.
Yes, and the point, I think it's very similar to the point I was making in opening.
So what have I missed?
The point I made in opening was what was plainly happening was that that insurer was using the potential of the Article 10 guarantee to respond as an argument to support its argument that there's no problem with it avoiding the policy. That's what was happening.
Well, that's not what it says.
Well, with respect, it is, because they're saying the strand of case law is saying that treating it as a nullity as against the victim is unproblematic. Why? Because the results required under the directive.
Well, where sorry to interrupt you, but where in the judgment does it say anything to indicate that that last sentence is more than is no more than a submission and is wrong?
Well, I can't really approve, and that's how I read it.
Well, that's a different matter. That's how you read it.
Yeah.
But my question remains, and I think the answer is nowhere. Where in the judgment does it indicate that the last sentence is merely a submission and not an accepted position?
No, you're right, my lord.
Thank you.
It could be read either way. We have looked out of interest for the order for reference in this case. The CJEU has fairly recently adopted a very useful habit of actually publishing the full orders for reference, and there isn't one for this case. And that's the kind of question that might be answered with the order for reference. In any event, the key reasoning in Fidelidade at 35 is to incorporate the Sonker restricted approach to Article 10. That's why it uses the words restriction by reference to the description of the categories of case that fall within Article 10, categories of case are identified as being a vehicle in respect of which no insurance contract is in place.
But it's directly against you again, isn't it? Because that paragraph starts with an acceptance of the fact that it's possible for the victim in those circumstances to receive compensation from the fund. And it's in that context that there's a reference to a restriction.
Yes, my lord, but I would rather suggest that the use or the structure of this paragraph is consistent with the analysis I've urged on you. But effectively what the insurer is doing is saying, look, there's no problem because the guarantee scheme will respond. And the court is saying, no, that's not correct. And our conclusions on effectiveness don't need to be any different. We don't need to embrace the potential for an exclusion of liability or an avoidance of the policy because of the existence of the fund. Why don't we need to do that? Why don't we need to reconsider our reasoning? Because, in fact, the payment of compensation by the body referred to in Article 1.4 is only envisaged for certain categories of case. And in particular, they say, it's only envisaged, and this is the language of Sonker, for a case where the vehicle in respect of which no insurance contract is in place.
So is it your submission that the properly understood paragraph 35 means that the first sentence is wrong?
No, It's not my submission that the first sentence.
Well, in that case, I'm very sorry. It's probably my fault, but I'm not following.
What they're saying in my submission is that you can't be plausibly arguing for a different analysis to that has proceeded up to paragraph 34, because the argument you're making, don't worry, everything will be paid for by the fund, is in itself wrong. Why? Because the fund only responds to two narrow circumstances of case: untraced vehicles and vehicles that have not satisfied the requirement referred to in Article 3.1. That is to say, a vehicle in respect of which no insurance contract is in place. Now, that language is impossible to reconcile with the interpretation urged by my learned friend, because my learned friend's analysis is, I'm still home and hosed against the guarantee body, even if a contract of insurance is in place. Even if the contract of insurance is in place, but it doesn't provide for the sufficient amount of cover, the minimum amounts, or even if it provides for the exclusion of certain risks, namely the twocking case, the example I gave you. That wouldn't be a case in which there is no insurance contract in place. It would be a case in which there's no compliant insurance contract in place. And yet, consistently with our analysis, the language is quite categoric. It's about the absence altogether of an insurance contract on the vehicle, and it must be at the time that the vehicle caused the injury.
Okay, well, you're certainly not.
Well, I'm wondering whether the fact that it's possible for the victim to receive compensation from the fundo is fact specific, case specific. In other words, it's that particular fund rather than the general Article 10 body that they're addressing. I mean, that seems to be what's said in paragraph 18.
That's another possibility, I suppose. I mean, yes, it is a possibility.
Paragraph 18 seems to be an analysis, right or wrong, of the one strand of the domestic jurisprudence.
Yep.
And the conclusion is then bolstered by the fact that in that jurisdiction, the fund...
That's a perfectly fair point. There's a third reading possible, which is that because of the particular vagaries, to use my learned friend's favourite word, of the Portuguese system, there's a top-up above and beyond the requirements of EU law.
It would be a stronger and clearer argument on that analysis.
Yeah, that's fair enough. I mean, the one point I would suggest that militates against both the alternative reasoning is what is then said at 36. Because at 36, they say, however, the fact that the vehicle is driven by a person not named in the insurance policy relating to the vehicle cannot support the conclusions that the vehicle is uninsured for the purpose of the third paragraph. And that, of course, is the very facts upon which the Spanish insurer was seeking to avoid the policy, just as in this case. So what they seem to be saying at 36 is that you can't rely upon the fact that the wrong person is driving as a basis for an avoidance and thereby treating the vehicle as uninsured when it is insured. There we have it. I mean, what I will say is ultimately this case comes down to the interpretation of this case. If I'm right in my submissions about Fidelidade and how Fidelidade builds on Shuker, and indeed if I'm right about Smith and Mead, what Mr. Justice J and what this court said in Delaney may be entirely understandable on the law as it stood at the time, but it is no longer sustainable in the light of these cases. And that's why I make no bones about the fact that, yes, of course, my learned friend is right to point to all the passages he pointed to in Delaney and say that they support his case. Our case is and always has been very clearly put on the basis that the law in the CJEU has moved on. If I'm right about that, I must be right about Delaney. All the things I heard from my learned friend, I didn't hear a suggestion that I could be right on the EU law and yet Delaney would nevertheless get him home. And for that reason, with respect, although it's confirmatory of my learned friend's analysis of some of the earlier case law, it doesn't get him home. It's not enough. The answer to this case lies in the EU authorities. If I'm wrong about that, then everything else will follow as night follows day. So, can I then lastly address Lewis and Tyndale? because I was accused of various solecisms in relation to Lewis and Tyndale. And would you allow me, first of all, to ask you to turn it up again, very briefly? The starting point for analysis in terms of breach was indeed paragraph 63.
Can you give us a page reference?
Yes, page 1141. Forgive me. All of this, as I understand it, was common ground. There wasn't any dispute about whether or not either Article 3 had been breached or Article 10 had been breached. So it wasn't a case in which the content of Article 10 was in any way being debated. The debate in Lewis and Tyndale was all about whether or not Article 10 was sufficiently precise to have direct effect, and whether or not the MIB was the emanation of the state for the purposes of meeting claims in respect of accidents on private land. What Mr. Mercer was attempting to do was to say all that there has been conferral upon the MIB of in terms of function is the function of discharging the Article 10 duties in relation to accidents on the roads. He's trying to split up roads and private land, saying we're only the emanation of the state for the purposes of roads. And that's why there was all the debate and the citation from Advocate General Sharpston that once you're the Article 10 body, you're the Article 10 body for all the purposes in Article 10. I'm not having that debate. We accept that if this is within Article 10, that we are the emanation of state. We're having a quite different argument, which is why I stand by what I said. There was no material debate in that case about the subject matter that is before you here, which is avoidance of policies of exclusion, whether a vehicle that was insured at the time of the accident was to be treated as uninsured. Simply didn't arise. It was a case solely on the fact that the vehicle was uninsured from the get-go. So speculations about how the arguments might have panned out otherwise are neither here nor there. And with respect, my learned friend speculates about whether or not the policies that operate for conventional road traffic insurance would have responded. I don't think the picture is as simple as he describes, because most people are indeed insured for certain purposes on private land pursuant to RTA policies. And I gave the example of driving along someone's private drive to get to their house.
Well, you're not an authorised insurer, unless A, you're a member of the MIB, and B, your policies comply with what is understood to be the RTA liability.
That's right. The whole debate about what constitutes public and private land is a particularly rich area of jurisprudence, much picked over as well. You know, accidents on somebody's site and whether or not the site's been restricted to access from the public, etc. That's another whole quagmire. But we can't really speculate about what would have happened if there had been a policy of insurance in place and whether it would have been avoided. That is a different scenario. It wasn't before the court in Lewis and Tyndale. The argument we have here is nothing to do with direct effect. You haven't heard me demur from what my learned friend has said about direct effect to one extent. It's not about whether or not we're an emanation of the state. I don't demur to any degree from what the Court of Appeal said in Lewis and Tyndale. We are an emanation of the state. The argument is about the scope of the duty, which simply didn't feature in that case at all. And the passages in the analysis of Lord Justice Flow, to which my learned friend pointed to, are all to meet the argument that the MIB was making in that case, which is we're the emanation of the state for this purpose, but not the emanation of the state for the purposes of accidents of uninsured vehicles that occur on private land. And the argument was met with, no, you're the MIB, you're the emanation of the state for all purposes, and no such subdivision is possible, whatever the MIB might have thought it was signing up to when it concluded the uninsured and untraced drivers agreements. So that's Lewis. And we say it doesn't answer the issue of EU law either. Again, we're back to fidelidade and only fidelidade.
It is really, it's fidelidade or bust, isn't it, for you?
It is fidelidade or bust. I do want to say fiddly-dee has my learned friend running all the way through. It sounds like the logical continuation of the Farrell and Whitty litigation, but I think it is fidelidade. There we go. And then the last point, but, you know, I understand why my learned friend makes it, but it was a jury's point. Yes, the exigencies of costs and cost funding are an unfortunate feature of how this litigation may pan out. But whether or not Quox is available or not, and whether or not a claim against the Secretary of State under Frankovich has to be funded in a different way, has nothing to do with respect with what the law is. And I obviously understand why he needs to make that submission, but I invite you firmly but sympathetically to reject it. Unless there's anything I can assist with further, that's all I plan to say in reply.
Thank you very much indeed.
And thank you for sitting late.
No, well, I think we procured the late sitting by our many questions.
My lordship, an important case. May I ask your lordships to sit about a minute later for something I want? I know I have no response, but there's one micro point my learned friend made which may not matter, but in case it matters, I'd just like to make the counter micro point, if I may. My learned friend pointed your lordships in relation to what I said about Smith and Mead being a pre-Farrell and Whitty case and all the rest of it. My learned friend pointed your lordships to Farrell and Whitty in Authorities Bundle 31, page 763, just to say, yes, look, but in Farrell and Whitty, that's 763, my learned friend placed some sort of reliance on the fact that the Advocate General's opinion in Farrell and Whitty number 2 was on the 22nd of June 2017. Not quite sure what the import of that was meant to be, but if it was meant to be something to do with how it might or might not have shaped the reference in Smith and Mead, I'll just remind your lordships that the reference in Smith and Mead, and I gave your lordships that reference, it's tab 33, page 851. The reference was on the 2nd of March 2017, for what it's worth. So before the Advocate General in Farrell and Whitty, number 2. This is all about the point about the national case. Once it's referred, and indeed, once it's referred, it's set in stone, and the questions are sent, and that's it. And it's not then subject to adjustment. The parties, the question might be reformulated, but the parties are never reformulated by the Court of Justice. That's the only point I wanted to make. And my lords, I'm grateful for the indulgence.
All right, thank you very much. We'll just rise for a couple of minutes to take stock.
I just find it easier to say. Quite enjoy saying
Fidelidade.
Yeah, well, there you go. You're more Espanol or Portuguese or whatever it is. Portuguese. There you go. I never got the hang of Portuguese.
It sounds like Spanish spoken by a Russian.
Yes.
Is my take on it. I often listen to pick up a Portuguese radio station. It takes you a while to realise it's not Russian.
It's not Russian. That's what I thought. We went to Portugal. I thought everyone. So many Russian tourists. And
You just cover the lip.
all Portuguese. It doesn't say. It doesn't reach you. summary grounds of resistance set in the modern slavery case.
What's been your for the slavers? Alleged.
I don't know how you guessed.
Well, it's the words resistance. Me and my forensic points.
It depends on the nature of the claim.
Now, what have you done to enslave the claimant?
Is it one of the diplomatic cases?
I'm not going to commit on an open lie.
One of Kathy's assistants.
It's actually an MIB staffing case.
Mr. Downer, Mr. Moser, thank you both again for your submissions, and our thanks to those who've assisted you and those behind you, both physically present and metaphorically present. You've given us plenty to think about, and you'll be astonished to hear we will reserve our decision. We'll aim in the usual way to produce a draft which will enable you to assist us with corrections of typographical errors and the like, but not please further argument. And the ultimate aim will be to hand down remotely without any need for further active participation. In the meantime, we'd be grateful if we could be provided with the material as to the absence of the Secretary of State from this particular hearing. Okay. So, thank you. I've noticed, Mr. Delamere, as a measure of the complexity of the case, that whereas Sherlock Holmes had a 3-pipe problem, you've had a 3-water bottle case.
Thank you, my lord.
Thank you very much.
Here we are. I'll have to summon someone to get the